Welcome to this edition of It's Case Law Review, and today we're studying a labor court case, HC Heat Exchangers versus Victor J L de Araujo, and this deals with a contentious issue on constructive dismissal. And why do I say contentious issue? I get to deal a lot with these kind of disputes these days, and employees just don't understand or don't want to accept the stringent requirements that they need to meet if they want to face or file a successful constructive dismissal claim. Just a couple of days ago, I think it was like 2-3 days ago, an employee sent me a WhatsApp asking me, does he have a case for a constructive dismissal case because, the employer subjected him to a performance review process and it makes him feel unwelcome. So I told the employee, look, maybe you should start performing. He subsequently resigned and now he wants to know. So contentious because a lot of employees feel that, a stressful environment, or my manager swearing at me, or challenges at the workplace that justifies a resignation and then subsequently claiming a constructive dismissal. So employees, it's not so easy. So let's study this case law from the labor court and let's see some pointers as to what constitutes a constructive dismissal claim, a successful one that is. So first of all, the legal basis. The LRA don't really elaborate a lot on the issue of constructive dismissal other than saying or providing for in section 186 subsection 1E a definition of what the constructive dismissal is. It's an employee terminated a contract of employment with or without notice because the employer made continued employment intolerable for the employee. This case, HC Heat, actually at some point puts quite some emphasis on that part of this sentence, continued employment. Let's park that for a moment. Okay, then they make reference to Eagleton and others versus You Ask Services, which basically laid down 3 elements. That is important that an employee who claims a constructive dismissal case must be able to prove in order for him or her to be successful and for the CCMA or bargaining council to actually have jurisdiction to entertain this matter. The first one is the employee must have terminated the contract of employment. So if you did not terminate the contract of employment as an employee, there will be no constructive dismissal case. Secondly, and you need to listen carefully, okay? The continued employment, not once off employment, continued employment had become intolerable for the employee. And number 3, the employer must have made continued employment intolerable, not your colleague, the employer. So in essence, if this issue relates to conduct between you and another employee, if the employer does not know about this, there's no constructive dismissal case here. Okay, it is the employer that must be the responsible party for making the continued employment intolerable. Okay, so in HC Heat Exchangers, this company, they manufacture and maintain heat exchanger, and they fall under the territory of the MEIBC Bargaining Council, and this is also ultimately where the arbitration was heard. Just, we're jumping a bit ahead here now. The employee did resign and did file a constructive dismissal dispute to the bargaining council. At the council, the commissioner or arbitrator found in favor of the employee, and therefore the employee was successful, which was thereafter overruled by the labor court. But we'll get to that. So first of all, this employee was employed as a health and safety manager at this company. And at this specific time of where this series of events that led to his resignation occurred, the employer wanted to move their workshop and wanted to build a bigger workshop. And because it was no longer operationally possible to maintain services with limited space in the capacity in terms of the workshop, the current one that is. So part of the concerns were that considering that this employee was then in charge of this project from a health and safety perspective, he was concerned that the employer did not engage or followed all his recommendations in terms of, ensuring a more health and safe working environment. He weekly had to submit reports, and as there was a looming deadline for this project to finish, I believe that was like on 15th of January the following year, this relationship between him and the factory manager also then becomes strained, especially from his side, because they are not actually following his recommendations or all of his recommendations. The employer stated that, look, every single recommendation that this employee made was duly considered, but they could not, for operational reasons, necessarily adopt all of his recommendations, but they did at least consider it, and they also had constraints in terms of operational capacity, and also they were short staff. But what they did then do is they listed all the health and safety recommendations in terms of severity, and in that sequence then they attended to all the health and safety recommendations made. But ultimately not all of the recommendations were implemented. What also aggravated the matter is that even though he generally or typically had a good relationship with the factory manager, at this time the relationship between him and the manager soured, because it seems like the employee was allowed to use the factory manager's vehicle quite often, but the factory manager became frustrated with the employee because every single time, allegedly, when he returns the vehicle, there's always a mechanical fault, and that he will not report the mechanical fault to the factory manager. He then denied access to the employee to use the vehicle, and later then the company then allocated the employee with his own company vehicle in order to commit to his duties. But unfortunately, the employee was unhappy with the company vehicle, and he raised that with the factory manager, and at that point in time the factory manager actually snapped. He became quite verbally abusive with the employee. He started swearing at him, and he actually threatened to harm him. So, okay, the two separated. They continued with their work, no further incidents or issues. The very next day, the employee reported for duty as normal. However, he did not feel well. He went to the HR and he wanted to report what happened the previous day, but told the HR, listen, he just wants to go to the doctor first before he reports what happened. And then the HR manager actually invited him and said, listen, come sit down and explain to me what happened, so that he can deal with the matters. The employee refused and said, I first want to go to the doctor. The only issue is the employee was then booked off for about 2 weeks, and he never actually, for another week or two thereafter, he actually never returned back to work. What he actually did do is, after the 2 weeks expired, he then filed for a protection order against the factory manager, submitted the grievance to the company, and then shortly thereafter he simply handed in his resignation. So that is basically the situation. So he was aggrieved by the employer not following his health and safety recommendations, but then also this spat between him and the factory manager. So we do have the first element of the three elements that can help with a successful constructive dismissal claim, in that the employee terminated the employment with the employer. So, let's just some highlights quickly in terms of some labor court judgments. Most of them are actually from AC heat exchanges and what was referred to inside this case study. Some very important snips of or clauses from this case law that will actually assist us in maybe have a better understanding as to how the courts look at the subject of a constructive dismissal, and thereafter we're going to look at how did the labor court actually deal with this matter. Okay, so in heat exchangers, the learned labor court judge argued in clause 44 that the best point of departure in deciding a matter relating to constructive dismissal is to understand that this concept does not emanate from the LRA. So, other than the definition, there's no elaboration really or additional provisions in the LRA or in the Code of Good Practice really that focuses on constructive dismissal. But it is a concept that was adopted by English law by the former industrial court in the course of the development of the labor law jurisprudence under the former LRA. This concept entails the notion that there existed an implied term in the contract of employment of an employee that an employer would not conduct itself in a manner designed to bring about the destruction or material damage to the relationship of trust and confidence underlying the employment relationship. So I suppose that's the foundation. It's actually called fiduciary duty. With other words, the foundation of the employment relationship from both the employer and the employee is one of good faith and goodwill between the parties. The new Code of Good Practice actually mentions this mutual respect between an employer and employee. So an employer must not deliberately try to seek destruction of this relationship. Okay, the court continues and then clarified what is meant, and this is the key word, what is meant by intolerability. You know, sometimes your employer don't greet you and this is becoming intolerable, no? Or they didn't pay you on time and this is intolerable. You know, I suppose we all have our own tolerability threshold, but you know what, there's actually the intolerability threshold in terms of law. It is a very high threshold, okay? So let's see what the judge is saying. In my view, intolerability is far more than just a difficult, unpleasant, or stressful working environment or employment conditions, or for that matter, an obnoxious, rude, and uncompromising superior who may treat employees badly. Even a breach of the employment contract, deductions from salary, or unfair disciplinary action would not per se establish intolerability. As you already can see, intolerability is a very high threshold. In Barker versus CCMA and others, the court said the following: intolerable is not actually defined in the LRA, but it's a strong word which suggests a high threshold. In this regard, Krogan, in his workplace law, states the requirement that the prospect of continued employment be intolerable suggests that this form of dismissal should be confined to situations in which the employer behaved in a deliberately oppressive manner. Okay? H. Heath continues to say the onus to prove the existence of intolerability rests squarely upon the shoulders of the employee party. The subjective views of the employee are of no consequence in discharging this onus, as the inquiry to establish where the intolerability exists is always an objective one. So first of all, your subjective feelings probably does not really play much role in this debate as to whether the continued employment relationship was indeed intolerable. It's an objective test, okay? In Bandit versus De Kock and other, the court considered the dicta in both Lourdes and Albany bakeries, okay? An important component of establishing such a genuine belief then has to be the use of suitably available alternative remedies, such as raising a grievance or using the remedies provided for in the LRA. As the court said in Albany, it can be considered to be opportunistic for an employee to resign out of the blue, so to speak, without even raising an issue with the employer and giving the employer the opportunity to remedy the cause of complaint, thus giving it a chance to remedy any errant ways. So not only must you bring this to the attention of the employer, typically through a grievance process, and if it is not dealt with to your satisfaction, also look at LRA remedies. You know, if it's discrimination, go to the CCMA. So unfair labor practice, go to the CCMA, okay? But then secondly, also giving the employer an opportunity to remedy. It's no good to submit a resignation and don't see it, not a resignation, a grievance, and not seeing it through. If you submit a grievance, you need to wait and see how the employers react and deals with the matter. And if they are making certain recommendations in addressing the underlying issue, you need to wait and see what the results are. Okay, you can't just resign and say, you know what, I'm suspicious that they're not going to do anything about this. Okay. In Eminent Corporation Supra, the court held, it may be that the appellant had a legitimate complaint about the performance outputs and appointments to his division, but such matters occur often and are run-of-the-mill points of difference or tension in any workplace. Grievance procedures exist for that very purpose. They are the compulsory means of resolving conflicts over run-of-the-mill disagreements between subordinates and their superiors. A proper application of the grievance procedure aims at testing the legitimacy of any difference of opinion and, through conciliation, hopes to find workable remedial solutions. So what I'm basically saying is that the purpose of the grievance procedure is exactly this. Let's try to resolve the matter, okay? Through a bit more conciliatory process. So you can't, you should not bypass that process, okay? And if you are going through the process, to short arm the process and maybe leave or exit midway or so, or even before the resolution started, you need to give the employer an opportunity to actually resolve the matter. Otherwise, how do you claim constructive dismissal, okay? And then in Barker, the court said, the labor court has held that if an employee is too impatient to wait for the outcome of the employer's attempts to find a solution to the perceived intolerable situation and resigns, then constructive dismissal is almost always out of the question. So, okay, let's just get back to the actual labor court judgment and see quickly how that was dealt with. What did the labor court have to say about this? Okay, so undoubtedly, there was an altercation between the first respondent, that is now the employer, and Dixon. That is the employee and the employer. So there was an altercation between the factory manager, who was a representative of the employer, and the employee himself. And this was on the 23rd of April 2015 already. In the course of this altercation, it is also true that the factory manager behaved in an entirely unacceptable manner. He lost his cool, swore at the employee, and threatened him with physical harm. There was no legitimate cause or reason for the factory manager to have behaved in such a fashion. In this regard, the findings of the employee are unassailable. It, however, cannot be ignored that the factory manager admitted that he had done wrong and said that he never intended to or would harm the first respondent, which is the employee. So he admitted, so listen, I'm wrong, okay? I should not have done this, but it is common cause. This is what happened. I did swear at the employee, and yes, I did threaten to harm him. But he continued to say the pressure caused by the unique event of the workshop move must also be considered. Nerden, who's the HR manager, also testified that everyone was under a lot of pressure at the time because of the workshop move and being present during the altercation, and knowing and working with the factory manager for 17 years, he did not believe the factory manager would ever have harmed or attacked the employee. The court continued, however, and even accepting that the conduct of the factory manager as aforesaid is the kind of conduct that can be seen to render continued employment beyond the limits of what can reasonably be tolerated and to be unduly oppressive, thus justifying the label of intolerable conduct. This does not automatically lead to a conclusion that continued employment with the employer were rendered intolerable, to the extent that the employee would have to be entitled to call it quits on the employment relationship and claim a constructive dismissal. So they are saying there's this isolated case, this isolated incident in which the factory manager sworn and even threatened the employee. But does this make continued employment intolerable? It does not seem that the court was actually convinced about this. Rather, the real question to answer is what the first respondent did when confronted, okay, with the state of affairs, and in particular whether he brought it to the attention of the applicant's responsible management, followed by consideration of what the applicant then did about it being so informed. So now they're asking, okay, there's this incident that happened. Did the employee report this to responsible management? In this case, it will typically be HR, okay? Considering, and then subsequently, what did the employer do about it, okay? Those are the real pertinent questions to ask, and that needs to be answered. Considering the nature of the incident complained by the employee and that it was perpetrated by one employee onto another in the course of a one-on-one altercation, it was essential for the employee to have brought it to the attention of the applicant's responsible management, such as, for example, the human resources manager or even a responsible director. The reason for this is simple. It simply cannot be said that the applicant, as the employer of the employee, acted in such a fashion so as to render continued employment of the employee intolerable if the employer is not even aware of what plagued the first respondent or the employee and was given the opportunity to try and fix this. So you cannot, as an employee, resign, file a constructive dismissal saying that the employer made continued employment relationship intolerable if the employer was not even aware of this. So if a fellow employee or even your line manager conduct himself in an unacceptable manner, it's still your responsibility to inform responsible management, a director, or maybe even your HR manager. Typically, a company will actually have a proper grievance procedure that you can make use of. There is an appropriate comparison that can be drawn with this kind of situation and the circumstances under which an employer can be held liable for acts of discrimination perpetrated by an individual employee by another employee. This is found in Section 60 of the Employment Equity Act, which requires that the discriminatory conduct must first be brought to the attention of the employer and that the employer be afforded an opportunity to deal with it before the employer can be held liable. Basically, again, confirmed by the Employment Equity Act that if one employee is discriminating, victimizing, abusing, or harassing another employee, before the employer can become liable, the employee, the victim, has a duty to report the said incident to management. As a matter of fact, it is Section 10 of the Employment Equity Act that also go further that before you file a discrimination dispute, you actually, let's say to the CCMA or to the bargaining council, you need to satisfy the arbitrator that you've actually tried to remedy this unfair discriminatory conduct first before they actually will have jurisdiction to deal with the matter. So there's a high price put on you reporting the matter and trying to resolve the matter. The point is that intolerable and oppressive behavior perpetrated by one employee upon another can only render an employer culpably responsible and liable for such conduct if the employer knows of it and is given a chance to deal with it, but then fails to do so properly and fairly. So, did the employee react as required? The judge is asking. In my view, that's a judge speaking, and unfortunately for his constructive dismissal case, he did not. He did not immediately report the incident to responsible management. He only intimated to Hilton on the 24th of April that he had something to report to her, but he did not say what. Declined her invitation to sit down and talk and instead said he needed to visit his doctor. He then left work that same day, never to return back to work and justifying most of his absence from work by way of a succession of medical certificates. In the absence of the applicant being informed about the event on the 23rd by the employee, it would not be able to establish from a reading of these certificates on face value that it related to such an incident or that the incident even existed. In short, the incident cannot be intimated from the certificates. But even under those circumstances and despite removing himself from the area of conflict, it still takes the employee until the 11th of May, which is close to 3 weeks later, to report the incident. Okay, this is also the same time when the employee obtains an interim protection order against the factory manager, rather than first approaching the applicants. It took him 3 weeks, then he reported the matter, and then he got an interim protection order against the factory manager. It has the hallmarks of a planned strategy, so to speak. Okay, with the applicant now being aware of the issue, what does it then do? Firstly, this is now the employer. Firstly, it is immediately dealt with by Hilton, who as HR manager would be the proper member of management to deal with it. Hilton immediately, the very next day, calls the employee and assures him that his complaint is viewed in a very serious light and will receive a proper attention. The first respondent, which is the employee, is told that a grievance meeting will be held and will be arranged with him as soon as he's back at work. This conversation is confirmed in writing by Hilton. Hilton also immediately proceeds to ask all involved to give statements. The first respondent and Hilton then actually agree on a time on the 13th of May when the employee will report at work to facilitate this process. The first respondent then does report at work on the 13th of May as arranged. He's asked to complete a proper grievance document, as he did not actually complete the proper grievance document. He actually then did submit it, but lo and behold, he did not plan to wait for the actual day of the grievance and instead resign. But what is interesting is in his grievance form, he did say that what he wanted, as a desired result, he wanted a proper working relationship to be restored and that he can submit a health and safety improvement plan so that the health and safety of the company are improved upon. That's actually what his desired outcome is. Okay, then finally, all the first respondent had to do was to return to work on the 18th of May and arrange with Hilton to set up a grievance meeting. After all, and up to that point, the first respondent had clearly indicated that this is what he wanted and was a willing participant in this process. However, and instead, early in the morning, on the 18th of May, the first respondent simply resigned with immediate effect, contending as a reason for this that his working conditions had become intolerable and his life has been threatened by the factory manager. He seemed to rely on the fact that his mere bringing of grievance was proof of this intolerability. He also complains that the applicant, the employer itself, was undermining his role as health and safety officer. The difficulty with all these justifications for alleging intolerable working conditions as contained in the letter of resignation is that it is directly contradicted by the employee's own grievance on the 13th of May, in which he specifically seeks the outcome that the working relationship be restored and his role as health and safety officer be given the necessary support. There you have it. The Labour Court didn't buy it. At the end of the day, the employer, as you can see, went well beyond to try and resolve the grievance, the issues, but the employee had nothing of that and instead opted to resign and claim a constructive dismissal. Intolerability, very, very high threshold. Anyway, that's it for this edition of Case Law Review. See you next time.